Kevin Flynn.
Rebecca Lavoie.
Do you know why we're here?
Is it a readathon?
It is. It is a readathon. It is Thursday, April 10th, 2025. And I have some news for you.
All right.
We almost have a jury.
Almost?
Yes.
We have how much of a jury now?
16 people have been selected, 8 men and 8 women, but apparently they want 18. 16 was like the minimum, and the plan going into today was I believe they had 15 going into today, but the plan was that if they got their jury, they were going to keep questioning people and adding more to the alternate pool. So right now, remember...
That's a jury and a half.
Yeah. The way that it works is that everybody hears the case and then the alternates are selected at the end, right before you deliver.
Yeah. So everybody pays attention the same amount.
Correct. So right now...
Because I tell you, if I was in high school and said, you may not have to take the test...
Oh, yeah.
I might not be paying completely close attention.
Yeah.
Exactly.
So right now there are 8 men and 8 women. And that's basically all we know. That's
all we know, because are the press allowed in the courtroom for this?
Yes, but they can't. They have a gag order.
They're barred from giving distinguishing characteristics about the jurors, like where they work or will they get their sex,
or what they're wearing.
What they're wearing. Okay.
I think they can just do gender, maybe race, but I haven't heard anything about the race, which makes me think they're probably all white.
Well, it is. Massachusetts.
Norfolk County.
Norfolk County. Yeah, all right.
Massachusetts isn't known for its, for those who don't know, Massachusetts.
In the urban areas.
The Boston area.
Yeah, okay.
Yes, but even the Boston area is not known for its racial inclusivity. Let's put it that way.
Yeah, all right. We'll leave it there.
So they're going to continue questioning jurors on Monday, potential jurors. And then the trial starts with opening arguments on Tuesday.
Oh, wow.
Guess who's taking the day off of work on Tuesday?
You are.
I am. I want to watch the opening arguments uninterrupted in real time, end to end, because I want to be able to yell out loud or whatever and have you hear me in your office, like in the moment.
Perfect. Exactly what I want.
What I want.
You have to walk out. Oh, no.
But the opening arguments, don't you agree, sort of set the tone? It tells you what they're planning to do.
Absolutely. So are we predicting that it'll be Brennan delivering the opening argument for the Commonwealth and Jackson?
Jackson
for the defense?
We already know that it's going to be Jackson.
Okay.
Yannetti did the opening arguments in trial 1, but this time it's going to be Jackson.
Okay, all right.
Interestingly, there is a new Karen Read Vanity Fair interview that came out today.
Okay.
She talks about a few things. She talks about how she feels like she understands the O.J. Simpson case better now, which is interesting.
Okay.
One of the things that she says is that when she watched the trial, like, she's seen a trial before or whatever, the O.J. Simpson trial, she thought all the lawyers on his team were like a bunch of snake oil salesmen. And now she realizes, she says, I don't think he's not guilty, but I do think that he didn't have enough evidence against him and he shouldn't have been convicted, which he wasn't.
Yeah, right.
So she sort of understands.
Spoiler alert.
And of course, that quote is getting her like a lot of shit from the anti-Karen Read people. But I've got to be honest with you. The prosecution did not tell a good story, which everybody needs. And there was one hugely tainted witness in that case, was there not?
Yeah. There's also 7 million pounds of DNA evidence.
Yes.
But anyway, I'll just say I understand her perspective. I don't know if siding with anything having to do with OJ is the best look, but it doesn't matter.
But even I think the not guilty verdict is completely understandable in trial 1. I do. We've watched it. We've watched the documentary.
Which trial? You mean the OJ?
The OJ trial.
Criminal trial. Okay,
yes. I think the not guilty verdict, I understand it. I think the defense did a great job with reasonable doubt stuff. And I think the prosecution made some very poor choices, such as asking him to put on the glove in the courtroom.
Yeah.
Poor choice.
Yeah.
Okay. So that interview, I will link it to the show notes. Basically, it's a pre-trial. Karen Read sort of talks about it, and I think the headline is something like, the second Karen Read trial is about to start and it's already a circus. But I am loving that Vanity Fair has a beat. And
cool. Does the Boston Globe
has a beat, but it's such weak tea. They had an article this week that really bothered me. I'm not going to say the journalist's name because I don't want to be a dick to another journalist, but this journalist, she put a message in a Facebook group saying, I am looking for sources to tell me they've changed their minds. They used to think Karen was innocent and now they think she's guilty. That's what that's the angle.
Yeah.
So when you go into a group and you say an article and you say your angle that specifically.
Mm-hmm. Oh, yes, I used to totally think she was innocent.
Exactly. And they also it also had a bunch of anonymous sources. And listen, I like the Boston Globe. I think the reporters are good. I think that angle sucks compared to other things they could be doing. What do you think?
I think it's a good place to go fishing.
Yeah.
I don't think to start, unless you're having a hard time getting people to talk to you to further explain what you're trying to do.
They say that they're scared. People who change their mind.
I'm scared.
So the whole thing that's interesting about it is, if you are aware that there's an anti-Karen Read movement, do a story about that. Do a story about the internet sock puppets, the trolls, the vitriolic speech, the sexist, racist, unbelievable speech of these people. At the beginning of jury selection, some racism flags were flying. It was unbelievable. Moving on, there was a motion that was decided upon in the civil case against Karen Read this week. Remember the civil case?
Yeah, this is the one brought by the O'Keefe family, wrongful death, but I thought that it would have been stayed until after the criminal trial.
It did. But the O'Keefe side, Paul O'Keefe, their representation,
the brother of John,
wanted to depose people now. Specifically, they wanted to depose Karen Read's father.
Okay.
And weirdly, Karen Read's brother Nathan's ex-girlfriend.
Karen's brother's ex-girlfriend.
Yes, Caitlin Boudreaux.
Okay.
So, and then this judge came out and was just like, yeah, no, you're not.
All right. Any idea? I mean, I guess we've already talked about some of the reasons why prosecutors and others against Karen wanted to talk to her father. Because they think that maybe something was said the night of or the morning after,
guilt,
things like that. Is this completely fishing, or is there anything out there that would explain why Karen's brother's ex-girlfriend would be a valuable source of information?
I don't know that, but I can guess pretty actively.
I mean, talk about double hearsay. Fuck? Karen told the brother. I heard the brother say that Karen told her. All right, yeah.
In a civil trial, you can depose anybody and you can ask them anything.
Yeah.
And if Karen Read's brother's ex-girlfriend doesn't like Karen Read, there is a chance that she would say negative things about Karen Read in a deposition, right?
Yeah.
Interestingly, there is an O'Keefe relative who has been thumbs-upping Karen Read innocent stuff on social media. People keep pointing out there is somebody in the O'Keefe family who's been doing that.
Interesting.
Yeah, so it's not
Paul
unilateral.
O'Keefe still married after all of his hot DM action?
All we know is that his wife has not appeared in court with him ever since that came out.
Interesting. Okay.
Yeah. All right.
Okay, so jury selection is nearly complete, and we seem to be on schedule for Tuesday opening arguments.
Yes.
Do we know when the View comes in? After arguments?
I think it comes in after arguments.
Because sometime, in New Hampshire,
it's before.
We had where the View was before, right? And and I'll just say that the judges, I should say the lawyers, were not allowed to make any sort of statements. They were allowed to say, note the distance between here and there and the whatever, but they couldn't start making things that, it was facts that were not in evidence yet, which I think makes it harder. I guess I think if I were a juror, or even if I were, a lawyer, I would like to be able to lay out what was important,
right,
and then affirm it with the things that you go to see. But all right, everyone does it differently, and okay.
I believe,
and you weren't prepared to answer that question.
No, it's fine. I know opening arguments come first because there hasn't been a View yet, and that's on Tuesday.
Yeah, right.
So I'm sure that in the opening arguments, somebody might say, when we go to 34 Fairview, you'll see X, and sort of prime them for that, right? So that's happening. So the View has not happened yet. Quick thing, the Supreme Court of the United States was asked to stay Karen Read's trial until they decide whether to take up her appeal or not. Jackson? Ketanji Brown Jackson? No. She was like, no.
So no cert on that. Okay.
No, but they are going to take up her writ of certiorari on April 25th. So that's when they will decide whether or not they're going to take up her
whether
case.
they'll take on a case.
Yeah. So people call it the writ of cert because that word is...
Certiorari is fucking horrible.
It's also,
word.
Everybody pronounces it differently.
Yeah.
On my podcast, Civics 101 that we do at NHPR, they say certiorari.
Certiorari, yeah.
So I'm guessing that might be right, but who knows? Anyway, writ of cert. That, by the way, for anyone who doesn't know, is the brief you write to the Supreme Court to ask them to take up your case. Essentially, that's essentially what it is.
And it's about granting cert. Would be about
we are taking the
going
case.
forward. Sure. Okay.
Yes. What it all comes down to is that their ask to delay this trial has not been granted, which does not, I think, bode well for the writ of cert, but that's just my opinion.
These are long shots, really. I mean,
total long shots.
To be clear. But it is an interesting concept about about whether or not the jurors should have been allowed to, or asked about which,
Right.
We've been through that. That is an interesting legal discussion.
Right.
So if any, as opposed to just saying, oh, they didn't give me the whatever.
Right.
But, okay.
But I think any intelligent person who's really been paying attention and also knows how the Supreme Court works, they take up such a tiny percentage of cases. This one has been boldly struck down by 2 previous courts.
Yeah.
They're unlikely to take
a lot
of
people say that it has infrequently to do with sort of how bad the miscarriage of justice is in a particular case. It's usually whether or not they can have a larger legal precedent or a legal issue that they can address with it.
That's right. Anyway. And they also can do shadow docket decisions.
That's a whole other can of worms. Thing. It sucks, but yeah, okay.
The shadow docket means they've decided in private with no arguments and they just write a note.
Completely untransparent.
It's very untransparent. Yeah. All right. Interestingly, another thing that I want to talk about is how does the press know what's happening in the case right now? Okay. Let's talk about that briefly.
All right.
The lawyers in this case have been, they're the subject of a gag order from Judge Canton saying you can't speak publicly about this at all. And I believe that includes Brennan too. It was Brennan's motion. It was granted. So outside the courtroom, there's this scrum of reporters that come out during breaks and lunch or whatever. And the scrum of reporters only has one person on the side of the Reed case that they can talk to. And that's Karen Reed. So Karen Reed has been coming out of court and saying, yes, now we have 16 jurors. And they're like, do you feel good about the jury? She's like, I feel fine about the jury, whatever. But they're talking directly to the defendant instead of, usually it's like Alan Jackson or Yannetti in front of the mic.
Yeah.
The only person who can speak on her own behalf is Karen Reed.
True.
That's weird.
It is. And I get the legal argument and the machinations of that. I question the wisdom of her doing that. But, yeah, you're right. I mean, if everybody's, the defendant has the right to speak publicly about their own case.
That's right.
And I'm even thinking back to what it took to keep Donald Trump from speaking to certain points of his own criminal or civil trials,
which didn't work.
Because of the clear and present danger to other people involved. Yeah. I mean, he's a unique case, but. Yeah, that's interesting. But as far as the wisdom of that, if your defendant is 1,000% innocent, you still may suggest that you may still counsel against them taking the stand. Why?
Because they could incriminate themselves inadvertently.
Inadvertently
or just
do
slip
something.
Up, inconsistency.
It's a slip up.
Right.
And that's what, in a way, all these media interviews, all this, there is a risk of that happening.
Yes.
For example, if Karen Reed were out on the sidewalk tomorrow and was talking about whatever, and just, I think the prosecution is going to try to say that when I hit John, that blah, 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 blah.
Right. She could make a mistake.
But then the prosecution goes up and plays this clip and says, right here, ladies and gentlemen, she admits to hitting John. Right.
Right.
And then she would have to be the, anyway, you get what I'm saying here. There's a reason why they say you don't need to testify in your own defense.
Right.
And even though she's pretty message disciplined, it's still a risk.
Here's how I think about it. She has said publicly and on that documentary that this talking to the media is her testimony. She said that. Yeah. So I don't think she's going to testify.
Yeah. No, she won't.
But her lawyers are 100% on board with her talking to the media. She's actively texting the Vanity Fair reporter. She's going outside with her lawyers and and we know they're on board because they let a documentary crew into their war room when they were planning strategy with the trial, and the lawyers were there too. Yeah. So they're on board with this, and I believe this is part of their messaging and strong feelings that she is actually innocent. And they, I think, plan to say when Brennan brings these things up is, do you think in a million years we would let our client talk to so-and-so if we thought for a second she had done it? They can say that. So
say that to who?
Well, it could come up in questioning. It could come up when he...
Probably not in court, but yeah.
Yeah, but it could come up in a closing argument, for sure.
Sure.
So anyway...
But then again, it shows that these jurors are not supposed to be checking the media. So anyway...
Right. But Brennan is planning to use media clips in the trial, so the jurors will see some of the media.
Okay.
So there's, that's the whole thing, is he's asked to do it and he's been granted the permission to do it.
All right, let's see how that goes.
We'll see how it goes.
Because they didn't do that in trial 1.
Right. I just think it's weird. I think it's weird that the very gag order that is designed to not taint the jury has led to the defendant being the only person who's allowed to talk to the media.
Because nobody had... It was a failure of imagination,
right?
That this defendant would be the one to take up that.
That's right. I think that Brennan assumes, like any normal lawyer would, that her lawyers would tell her to not say anything. Mm-hmm. Yeah, he's wrong.
Yeah. Generally speaking, the reason these rules are put in place, as far as like tainting the jury, it's not necessarily a argument about a point of legislative law, right? It's more about judicial ethics and procedure and court conduct, so that basically the sanction might end up being something to do with the bar and your law license, as opposed to, unless it's contempt, going to jail.
Right.
Basically, that means that those kinds of rules only apply to lawyers because of professional
sanctions.
Yeah, because of that. So I don't want to say like the judge is powerless to keep Karen Read from talking to the media.
The judge is powerless to keep Karen Read from talking to the media.
Well, I mean, but it would have to be a completely different order, crafted in a whole different way, subject to appeal and yada yada. But I mean, that's why she can write a letter saying none of you guys and gals can say anything.
Right.
But Karen can walk out, and I mean,
Karen Read.
I don't know, like, if that endears her to the judge or not, but
probably
we're
not.
way beyond that.
But Karen Read has the First Amendment right to speak to the media.
Sure.
Granted, the First Amendment is the rights afforded under the First Amendment have been eroded somewhat, especially in this case.
Yeah.
But she has the right to speak to the media. She has the right to talk to whoever she wants to talk to.
I think secretly both sides want Karen Read to keep talking.
Yeah, 100%. So the thing that I wanted to mention about Hank Brennan.
Yeah.
In the Vanity Fair story that came out today, they interviewed a colleague of his, a colleague that had co-tried a case with him. I believe it was the Whitey Bulger case. And this colleague says that Hank Brennan is the best cross-examiner they have ever seen in court.
Okay.
And
I knew he brought something to the table.
He has to bring something, because it can't be his oral skills, spontaneous oral skills. But he apparently is a great cross-examiner. He's caught people off their foot. He asks the first question that's like a punch in the face. That's what he's known for. But you know who else is a great cross-examiner?
Alan Jackson.
Yeah, so it's going to be like the battle of the cross-examination.
It's interesting because I don't know. I'm thinking about the witness list. I don't know if there are any like defense witnesses that really need to get punched up, because it seems guys. Like the ARCA guys, good point, and the dog bite expert, that doctor, but the rest. But I mean, like, the people that really ought to be watching their back are the Mick Alperts, because those are the one, like, that kind of cross examination could be devastating.
It could, because they could literally point to the first trial and said in an earlier proceeding,
you said this,
in the first,
and a completely different proceeding, you said this,
right, exactly. All right, so finally. Yes. We have to talk about Canton, Massachusetts.
Canton,
By the way, I found myself wondering, is Canton one of those towns that has the all caps on their sign? Welcome to. Have you seen those Massachusetts signs where it says "Welcome to" and then the city name is in all caps?
And the white sign that every town has, every community has.
Yes. So
I haven't looked that closely.
I know my
hometown had one.
It's traditionally in all caps.
Okay.
I learned something interesting today.
What's that?
When you see one that is in a sentence case, capital letter and then all lowercase, in 2009, there was a recommendation from like the state highway people to do that sentence case because older people apparently have an easier time reading sentence case than all uppercase.
Okay, boomer.
So if you see one of those signs that says "Welcome to Ken," where it's all like uppercase, it's a sign that predates 2009. Fun fact. Okay.
Interesting fact. All
right. Canton has a select board. The select board members serve 3-year terms. This past Tuesday, there was a town Canton election. Now, town elections, for those of you who don't live in tiny-ass New England, are when they elect things like the dog catcher, literally, the library trustee, the person,
probate,
the clerk.
Cemetery,
I mean, I know
library,
a lot of towns have that, but in New England, it's definitely like a thing, right?
And it sounds like in the select board that the terms are staggered.
Yes.
So they're not doing an entire
it's
board.
Two and one. So they stagger them every year.
2, 2, and 1. How many? Is there 3, 4,
There's
5? 5. Okay.
So in year one, they elect 2. Right. In year 2, they elect 2. And in the third year, they elect 1.
You can't throw all the bums out at once.
That's right.
All right.
And the way that it works, typically, when there's 2, we have this in our town, is that there'd be like 5 candidates and it says pick 2.
Mm-hmm. Yep.
So the 2 people with the most votes win.
Yeah.
So the chair of the Canton Select Board has been a guy named John J. Connolly.
Mm-hmm.
You've seen him, whether you remember it or not, at those Canton Select Board meetings that I've played tape of before and shown you YouTube videos of.
Yeah.
He is the white-haired, red-faced, angry guy who sits in the middle and yells at people.
But if you had to characterize sort of where he is politically regarding the Karen Read case, he is very
florid and angry.
He appears to side with
pro-police
and
and which, by the way, I don't want to say pro-police as a blanket thing because that means different things to different people. Mm-hmm. In this particular case, it means that our police didn't do anything wrong in this, and that Karen Read is guilty. Blah, blah, blah.
Right.
So he was challenged in this election. I just want to mention previously he has won his seats by a lot. Like he's won with like 30% of the vote when there have been 5 candidates and so forth.
12 terms? 12 3-year terms? He has served
12 terms.
All right.
He has been on the Canton Select Board for 36 years.
Jesus. Okay.
So this time he was challenged by...
It probably doesn't pay anything either, right?
No. Right. This time he was challenged by a woman named Susan G. Harrington.
All right. What do we know about her?
This is the 1 year. So only 1 Select Board member was going to be elected in this year. And there were only 2 candidates. John Connolly and Susan Harrington.
Okay.
So I looked at Susan Harrington's campaign website. Mm-hmm. In the campaign website, on the About Me page, it says, I respect and thank John Connolly for his 36 years of dedication to Canton. By the way, I personally don't believe any elected official should be in office for 36 years.
Oh, sure. Right.
But, she says, after nearly 4 decades, it's clear. Canton needs fresh leadership, a renewed commitment for transparency, and a select board that embraces the future, not just the past.
And not just Canton.
Listen to what she says next. It's time for our select board to truly support our police, not just in words, but through real oversight and resources.
Oh, okay.
It's time to ensure that each resident of every background feels heard, represented, and valued in the decisions shaping our town.
So to say that we have to support the police does not mean that she comes out down on the side of the police in this case. What was the thing that she said right after that?
She said it means support our police not just in words, but through real oversight and resources. Yeah.
Okay.
So in this election,
I guess I'd say that when I would go to vote, I would wonder where she actually is on that. But okay.
Yeah. So the people came out.
People have spoken.
And Susan G. Harrington received 3,264 votes. Mm-hmm. And John Connolly received 1,820 votes.
Drubbed. He got skunked.
I would call it a pounding.
It is. It is. I
mean, just for perspective, I looked up some of the historic select board elections, and they've all been really close.
Right.
So, the previous 2-year one in 2024, there were 1, 2, 3, 4 candidates, and the numbers read like this: 32-23, 29-17, 27-36, 26-21. So they're within like a quick range. In 2023, it was 1997, 2274, 2151. So it's typically tight.
300 votes a different way would have gotten rid of Chris Albert.
Chris Albert won that year, by the way, got the most votes.
But by 300.
Yes. Chris Albert, by the way, is up for election again next year. So this was in my opinion, looking at the previous election results, an unprecedented a result. She got, I don't know, almost twice the amount of votes he did. And that's saying something.
Yeah, I mean, we saw over the summer the anger at these different public hearings, whether it was the select board or some other things, that whole audit thing, or whatever it was. It definitely seemed like at least the people who came were making a pledge that politicians, will pay for their positions.
That's right.
And I mean, this certainly seems to be a result of that, because he seemed to come down as somebody that would be, I don't want to say anti-Karen Read because it's not about a particular case.
You can say that.
But it's that side.
He has shut down people who've stood up to speak about the misdeeds of the Canton police, the Sandra Birchmore case. He shuts them down. He's in charge of those meetings. He runs those meetings. He's the one who tells the police to drag people out of those meetings. It's this guy.
Yeah.
Or it was this guy.
It was this guy. Wow.
So
okay.
So it's interesting, like the turnout was high, and in every other election there have been, like a couple dozen or a dozen or so like write-ins, others. There was one.
One write-in, huh?
The people felt pretty strongly that
nobody wasted their vote.
Well, there were 18 blanks. There are always way more blanks. There were 700 blanks in the previous election, and there were 1,400 blanks the previous election before that. There was 18 blanks in this election.
Wow, it sounds like a really motivated
electorate.
But yeah. People came. They did not play.
That's right.
So what's interesting here is, like, if you're going to read the tea leaves and what the political winds are in that part of the state, these are also some of the same voters who will vote for the district attorney.
Yes.
So if I am Morrissey, Meatball Morrissey, whatever you want to call him, District Attorney Morrissey, who has been around for how
10 million years.
10 million years. I mean, I think I would have to see that there is trouble brewing here as well.
Mm-hmm. And he is up, I believe, for election in 2026, which is next year.
Right. And he has very rarely, if ever, had...
He's never been primaried.
Primary opposition.
He has never been primaried.
Right.
And he is going to be primaried this time. There have been two people who have already put out their intent to primary him, and one of them apparently has raised a shit ton of money.
Yeah, and then this is one of the areas of the country where primary is essentially the general election.
Yes,
because
the Democrats always win.
Yeah, it's really the Democrat. Right, and that's what everybody who replaced Ted Kennedy thought, and then hello, Scott Brown. But anyway.
Yeah. So maybe our listeners need to understand this, because I often say that a lot of people involved in this case are like MAGA-oriented. Mm-hmm. They are. They really, really are. But... Republicans don't even run. The Republican Party, the state party, the national party puts no money into Massachusetts races because Republicans so seldom win then. But Democrats in Massachusetts...
Charlie Baker, Scott Brown. I mean, there are some, but they're very liberal Republicans. So Mitt Romney was the governor of Massachusetts, and he's the one who did Obamacare before it was Obamacare, requiring everyone to have insurance. And if you are an another
employer...
prominent Republican. Yeah, it happens, yeah.
If you are an employee of a company in New England and you live in Massachusetts, like my company, we live in New Hampshire, where insurance rules are very loose. And then if we have an employee who lives in Massachusetts, and we have many, we have to provide them with better insurance than we provide to people in New Hampshire, because Massachusetts is a state that has that. But I will say the product of having such a Democratic stronghold in Massachusetts is that Democrats don't always behave or speak or espouse the values that you would imagine Democrats would in other parts of the country. They're not super liberal. They lean more toward the middle. Some people would say Mayor Wu in Boston is a exception, but they're more like the Kennedy Democrat model.
Some are, but I mean, it's still Texas.
Well, we still have Warren. They still have Warren, which is But in terms of but in terms of like Democratic prosecutors win elections. Mm-hmm. They are anti-crime. They are tough on this. They're tough on, and it's not exactly the same message that you might get in other parts of the country when Democrats run. So I'll just leave it there.
All right.
So so that's where we are. Trial's supposed to start on Tuesday. Mm-hmm. More jury selection on Monday to get those last two on the panel. Mm-hmm. And the Vanity Fair article, which I'll post in the comments, and the select board election.
Interesting.
So that's where we are, Kevin. On the Thursday before trial, there's no court tomorrow. So this is essentially the Friday before trial.
Get your popcorn, people.
Yeah, it's on. What do they say? What do the kids say? Let's fucking go!
LFG!
Kevin, thank you for joining me on the Readathon.
You're welcome.
Partners in Crime Media.